Okay, let's dive right into this explainer and tackle the absolute most common question we get about New York personal injury lawsuits. Look, if you've been injured and you're stepping into the legal arena, you want justice, and you probably want it yesterday, right? But the legal system definitely runs at its own pace. So today we're going to break down exactly how that system works step by step and focus on the big picture timeline.
Why is my case taking so long? We hear it all the time, and we're going to validate that frustration today. It is completely normal to feel like things are just dragging, but by the end of this explainer, you're going to understand exactly where the bottlenecks hide, why the courts actually require them, and what's really happening behind the scenes when things seem perfectly quiet on your end.
To set our expectations right out of the gate, we're looking at 24 to 30 months. That's how long a typical lawsuit in Erie County takes from the moment of filing all the way to a trial. And keep in mind, if you have a really serious injury case involving multiple doctors, hospitals, or expert witnesses, well, it can take even longer. Every single case is unique, but this is the baseline reality of the timeline.
So here is our roadmap for today. We'll look at the big picture timeline, how we actually start the legal clock, why the discovery phase causes so many delays, the final path to trial, and crucially, what you can personally do to keep your case moving forward.
Section 1. The Big Picture Timeline. The first few months of the legal process certainly don't happen overnight. First up, filing the lawsuit takes about 30 days. This kicks off when a summons and complaint is officially filed with the court. It lays out who caused your injuries, how they were negligent, the damages you suffered, and the compensation you're seeking. Next, actually serving the defendants can take up to 120 days. Professional process servers have to physically deliver the lawsuit according to some pretty strict New York laws. And finally, we wait for the defendant's answer, which adds another 30 to 45 days. This is where the defendant's insurance company hires an attorney who, no surprise here, typically denies responsibility and raises their legal defenses.
Section 2. Starting the legal clock.
The really crucial point to remember here is that those first three steps, the filing, the serving, the answer, they just set the stage. At this early point in the timeline, absolutely nothing has been proven. The complaint simply starts the legal process. It's basically the starting gun for the race, which leads us directly into the longest and definitely most complex part of the entire journey.
Section 3. Why discovery causes delays.
So discovery is a massive 9 to 12 month phase. During this chunk of time, both sides are heavily gathering evidence before a trial can happen. They're exchanging documents, pulling medical records, reviewing wage loss info, taking depositions, and scheduling defense medical exams. Now, discovery is mandated by New York rules to keep trials fair, basically ensuring no one gets ambushed by surprise evidence in the courtroom. But because it relies so heavily on outside parties doing their jobs, it is the absolute primary culprit for case delays.
Let's drill down into why that is. Under New York law, defendants have a legal right to obtain your medical records directly from your doctors. So your legal team hands over signed HIPAA authorizations so the defense can order those records themselves. But here's the massive bottleneck. If hospitals or medical admin offices take months to respond, which unfortunately happens all the time, the defense will simply throw their hands up and claim they aren't ready to proceed. If literally anyone with control of relevant info fails to respond quickly, your entire case hits a roadblock.
And this creates a highly frustrating chain reaction. Think of it like dominoes. Defense attorneys generally demand all of your medical records before they'll even think about scheduling your deposition to question you under oath. So step 1, waiting for records, completely stalls step 2. And they absolutely will not conduct their medical examination, step 3, until after that deposition is finished. It's just a domino effect of delays, and it all stems from how long it takes to squeeze administrative paperwork out of medical providers.
Now, you might be thinking, well, can't we just tell the judge? It's a fair question. We absolutely can ask a judge to step in and force the defense to speed up. But here is the stark reality of asking for court intervention versus just moving forward naturally. It is almost never a quick fix. If the defense can show the judge that they've made a reasonable effort to get your records and they're just waiting on the hospitals, judges will almost always just grant them an extension anyway. Plus, scheduling those court conferences and filing motions just adds even more time and legal expense to your case.
Once those records finally do arrive, the dominoes can start falling. First up is your deposition. This is your sworn testimony given before trial, recorded by a court reporter. There's no judge present, but you are under oath, and the defense attorney is going to question you for about 2 to 4 hours. It's vital because the defense finally gets to hear your story directly from you. Following that is the defense medical exam. Now, you might occasionally hear this called an independent medical exam, but let's be real clear here. It's not independent. This doctor is selected and paid for by the insurance company to evaluate your injuries.
Section 4. The path to trial.
Getting to the note of issue is basically seeing the light at the end of the tunnel. Filing this specific document tells the court 3 critical things. Discovery is officially done, both sides are ready, and this case needs to be put on the trial calendar. It marks the official transition from the long investigation phase right into intense trial preparation.
But getting on the calendar certainly doesn't mean you're going to trial next week. The court will hold a readiness conference within about 45 days, and jury trials in Erie County are generally scheduled another 9 to 12 months after that conference. It really depends heavily on the court's calendar and just how complex your specific case is. However, this waiting period is actually incredibly productive. Both sides now fully understand the strengths and weaknesses of the evidence. Because all the cards are finally out on the table, this is exactly the phase where a lot of cases successfully resolve through settlement discussions.
Section 5. Keeping your case moving.
So while court rules and defense tactics are largely out of your hands, let's talk about what you can control. By strictly following these 5 steps, you give your legal team the fuel they need to respond rapidly to the defense and push back against those delays we talked about. You need to attend all your medical appointments. If you see a new doctor, report it to your legal team immediately. When they send you a medical authorization, sign it promptly. Respond to document requests the absolute moment you get them. And always keep your legal team updated on any changes to your address, phone number, employment, or treatment. The faster you provide information, the faster your team can drive the case forward.
And finally, if the case goes all the way to a trial, making it through all the preparation of witnesses, exhibits, expert testimony, and closing arguments, never forget this incredibly empowering fact. At trial, the insurance company no longer decides what your case is worth. A jury does. The delays in the system can be agonizing, for sure, but isn't securing the true value of your case, decided by your peers rather than an insurance adjuster, worth the time it takes to build an undeniable case? Keep that in mind as you navigate the road ahead.